Welcome to Divorce in Custody with Ryan, the real process explained.
Hello, everyone, and welcome to Divorce in Custody with Ryan Johnson. Ryan is a senior partner at Johnson & Taylor in Salem, Oregon, and he focuses on divorce, custody, and family law matters across Marion, Linn, and Polk counties. This podcast provides practical guidance for individuals who are considering divorce or maybe already navigating a family law case. In this episode, we start with a broad overview of how divorce works in Oregon and what to expect as the process begins. Ryan, great to see you.
Nice to be with you.
Excited to begin this podcast journey with you, and I think it's going to be great. What's the first few things someone needs to know before filing for divorce in Oregon?
Yeah, I think what they need to know is at a very foundational level, it's this. Do you know and understand all the consequences of getting a divorce? So look, I'm very pro-marriage. I think marriage can and should be a beautiful and healthy thing, but human relationships, they take work. They're complicated. I always, I'll tease with my clients and say, the first 50 years of marriage are the hardest, and you get a chuckle, but it's true. Like a healthy marriage takes a lot of work. And there's countless studies on the benefits of marriage, mental and emotional health, physical longevity, physical health, and that's not even getting into the benefits of it is for children, right? But the caveat with all that is that it has to be a healthy marriage. So when you're contemplating a divorce, you need to ask yourselves, do the consequences or the outcomes, because consequences can be positive or negative, do the consequences of a divorce, are they gonna outweigh the potential benefits? And so what are some of those consequences? Well, if you have children, for example, are you okay with the idea that you are likely no longer going to tuck your kids in bed every night? Because some nights they're going to be with their the ex, right? Are you okay with, you're not going to spend every Christmas with your little kids anymore? Some of those Christmases will be with the other parent. And then, of course, there's the financial consequences, right? You don't become financially better off going through a divorce. This is basic economics. You're going from one or two incomes and one household to one or two incomes and two households. So you're losing these economic efficiencies. And so, but of course, there are potential benefits, right? So if you're in an abusive relationship, or if the children are stuck and witnessing a pervasive, toxic relationship between you and your spouse, and the relationship for one reason or another is just not salvageable, then perhaps, the negative consequences of the divorce are swallowed up by the potential benefits. So marriage is not a trivial thing, and therefore divorce is no trivial thing. And so they need to go into it with their eyes wide open, right?
Yeah.
They've talked with close family members. They've talked with friends. They've perhaps talked with a good counselor, and they've weighed all of these pros and cons.
Yeah, that's good. That awareness and just eyes wide open and a full awareness of the consequences. So let's, for the purposes of our discussion, someone has done all of that. They've done that analysis, that reflection, and they've decided to move ahead with a divorce. What is the very first step in filing for divorce in Oregon?
Yeah, so the very first step is going to be filing what's called a petition for dissolution of marriage. So this is the very first pleading that would ever be filed. Nothing can get filed until this is filed. And this is just a very general petition for relief that's submitted to the court. And is essentially asking, usually it's very general. It's asking, hey, I want my marriage dissolved. I want you to determine, this is who I want to have custody. I want a parenting plan that's in the best interest of the children. I want child support. I want our finances and debts to be divided in a just and proper way. I want spousal support. So very general. And there's potentially a lot of strategy and a lot of pitfalls here as to whether or not you file a petition with very general requests or very specific requests. And, that's maybe a topic for a different day, but it
Hmm.
starts off with a petition for dissolution.
Got it. Well, yeah, and as you described that, and then it could also include all of parenting plans, spousal support, et cetera, et cetera. I, for one, wasn't aware that all of that detail went into that initial petition, but I guess, I mean, also there's some flexibility there. So let's move it forward just a step and say, okay, so you've done that. What, what's next after that? Because like you said, nothing can happen until that petition is filed. So the petition for dissolution is filed, and then,
Yeah, and then so obviously, well, maybe not obviously, but you have to have give your spouse legal notice, and what we call that is you have to have them served. So you can't have any type of relief granted to you typically until your spouse is on notice that you've actually filed this. So it could be that you've talked about it. Your spouse could actually know that you filed it, but until they are legally served with documents, nothing can really meaningfully move forward. So they get served, and then what happens is they have a certain amount of time to respond to that petition. So what they're going to do typically is file a response to the petition, and they're going to go point for point, and they're going to say, well, I agree with this, or I disagree with that. And they'll go point for point on your request for belief. And then they'll file in conjunction with the response a counterclaim, and they'll say, well, and this is in contrast to what the petitioner or the first parent or spouse to file wants. I want this instead. So that's going to be called the counterclaim. So once the petition and the response and counterclaim are filed, then you're off to the races. And
got
the case is full go, and you're in the court system,
it.
and off you go.
Right, and so there we are. We're early in the process. Those those the petition and the response have been filed. What about, you're in this sort of interim space, right? And you've got issues of living arrangements and parenting time and finances. How does that get handled early in the process?
Yeah, really good question. And, super complicated in a lot of ways, but I'll try to break it down um, maybe perhaps a really simple principle. And applies to temporary issues like what happens during the divorce with my finances, with who's living in the home, with the children. It also applies to any aspect in the divorce, and it's this: there are two ways to resolve any issue in a divorce case. The first way is you and your spouse agree on that issue. The second way is you can agree, and therefore the judge is going to decide that issue. There is no other way. There's no sort of magic, wand that happens. You and your spouse either agree on the issue, or the judge decides that. Let me give you an example. So you filed the paperwork. They filed a response. In your paperwork, you say, "Well, I want to be awarded the home," and your spouse says, "Well, no, I want to be awarded the home." So then you're in this situation where, like, okay, we both want to be in the home, and we want the other one out. What happens? Well, the answer to that is actually nothing until the two of you agree. Okay, fine, you can have it. I'll leave. Or you say, "No, I want to stay," and the other spouse says, "No, I'm going to stay." Then you have to set a hearing. You have to go in front of the judge, and the judge is going to decide, okay, you get to stay and you have to leave. And that's the same principle in every single issue, big or small, in a
Yeah,
divorce case. You figure it out with your spouse, or the judge will tell you.
yeah. Well, what about I mean, you're in a negotiation dynamic there. Where do negotiation and mediation fit into an Oregon divorce?
Yeah, so let's start with mediation. It used to be, just a few years ago, actually, it used to be that mediation was required in every case where children were involved. And what I mean by that is after the response was filed, the court would assign a mediator. And this is a court appointed mediator paid for by the court. And they would say, look, you have 4 hours, typically 4 hours or 8 hours to work with this couple to try to resolve some of these issues. And mediation, at least in Marion, Yamhill, Polk, and most counties, they only work with custody and parenting time. They don't do financial issues. They don't do child support. They don't do spousal support. They want to work with the couple on let's get the kids figured out. And so the parties could, go into mediation and try to work as far as they could in mediation. Maybe they reach a full agreement. They agree on everything. Or maybe they reach a partial agreement and they can't agree on everything, but they agree on some things. But recently, judges have been more willing to waive mediation. I think the idea there is finding that, forcing someone to mediate is kind of counterintuitive to what mediation is. Mediation is the idea that, it's going to be a give and take. I'm not going to get everything I want, but maybe if I give it this, I can gain this.
Yeah.
But if people go in and they're like, no, I want what I want, I've drawn lines in the sand, then it's a big fat waste of everyone's time and court resources. So that's kind of where mediation falls. It's a great thing. Don't get me wrong. It's a great thing if couples are willing to work on that with each other and with the mediator. It goes back to our point that mediator assists them in coming to an agreement, and you don't need to get the judge involved. So that's positive. Now, negotiation, I mean, that's happening throughout the entire case, right? So ideally, your attorney is continually working with your spouse's attorney to make agreements on things. And it could be little things. It could be big things. You don't have to agree on everything. You can agree on as much as you can. But the negotiation is happening behind the scenes with attorneys and with clients, helping your client become accustomed to what the realities of what they're up against if they go in front of a judge. So as an attorney, you're negotiating with your client saying, hey, I know you want this, but I don't think that's a good idea. And then you're negotiating with the other attorney saying, hey, my client would really like this, but maybe they're willing to give up this. And so that's happening all the time behind the scenes.
Yeah, that makes sense. This is maybe overly simplistic, but I'm curious what happens when, both parties are able to reach agreements, right? But then also, more likely is what happens when parties can't agree on major issues. I mean, how does that dynamic play out? Is it like, oh, we agreed, so boom, 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 we're done? And
Yeah. And that's the ideal outcome, right? Like you want there to be full agreements. It's faster. It costs less money. Both parties have presumably bought in. And maybe it's not a deal that they love, but I always say you don't have to love it. You just have to live with it. Can you live with it?
Yeah.
And because it's agreed to, there's less likely to have future enforcement problems. So if there's agreement on all terms, you can simply sign a judgment. Your spouse signs a judgment. The attorney signs a judgment. You submit it to the court, and the judge signs it, and you're done.
Yeah.
And you can also come to an agreement on everything but. So you could come to an agreement on all sorts of issues, but still have a few outstanding issues that the judge needs to decide. That's good. It's not the ideal, but it's better than not coming to an agreement on anything. And then to your second question, well, what happens when the parties can't agree? It goes back to the principle I discussed earlier. Like if you can't agree, the judge is going to decide.
Got it.
And when you can't decide, you are then subject to the court system in its fullest power. And I say that meaning you're subject to the court's calendar. You're subject to all sorts of discovery, rules that maybe court orders that are going to require different types of evidence be brought before the court and determined in advance, and all sorts of things. And so that's when you're in the full gamut of the court system, and you lose control right when that happens. In an agreement, you have some type of control, but when you can't agree, you're just saying to the judge, hey, it's in your hands.
Yeah.
Not ideal, but certainly happens.
Yeah. I mean, I'm sure it does, right? But yeah, it does sound a bit of worst case scenario, so to speak. But let's talk timing. I mean, you just laid out a couple of things where obviously if my spouse and I or former spouse come to an agreement, bing, bang, boom, things are moving. That implies that that's faster. But how long does a divorce typically take in Oregon? And what I mean, anything can affect that timeline, but what are the major factors?
Yeah, no, you're right. And so, yeah, the biggest factor is going to be, are you going to agree on the big pieces? Because divorce cases and issues in divorce cases are kind of like magnets. You get close enough, right, that eventually they're going to snap. So if you get the big pieces agreed upon, then the small stuff kind of snaps together. But sometimes you can't get agreements until you have enough information. And so even though you may believe like, yeah, we're going to come to an agreement, you still need documents, you still need finances, you still need to know what the playing pieces are to be able to determine how do we settle it. So that can be a big one if you have a lot of discovery, a lot of, assets out there that need to get, we say discovery needs to get, found out, like what exists, how much is it worth? So that could be a big one. And then, of course, if you cannot agree on any issue, so even if you have a 99% agreement, but you're just out one thing, you're in the court system, you're in the court calendar waiting for the judge to set a hearing date. And that can take, a year, could take over a year. I've had cases go 2 years. So it really depends. But if you want to control the timeline, you work on coming to an agreement and you work on getting your discovery done.
Got it. No, that's super helpful. We're coming up on time, but I want to put one more question to you. Kind of getting, sort of tying this up in a bow almost. What decisions are finalized at the end of a divorce in Oregon? I mean, obviously, the judge puts a stamp on a divorce.
Yeah, for sure. And so again, it goes back to some of the issues, the main issues outlined in the petition and in the counterclaim. And there's really only a few. The devil's in the details, right? But there's a few. So they're going to decide if you have children, who's going to have custody of those children. They're going to decide a parenting plan, like what is the schedule that the kids are going to be on. They're going to decide child support, who pays it, how much, how long. They're going to decide the division of assets and debts, who's taking what, who's paying for what. And then they're going to decide, if applicable, whether or not there's a spousal support award, meaning one parent is paying the other parent, or I guess not even parent, one spouse is paying the other spouse a monthly sum to kind of help them move past the divorce financially.
No, well, that's great, man. Very clear. A great primer on divorce and the process in Oregon. And I really enjoyed that conversation, Ryan. I look forward to getting together again on future episodes.
Yeah, appreciate it, Sean. Thanks for your time.
You bet. That's it for this episode of Divorce in Custody with Ryan Johnson. If you're considering divorce or dealing with a custody matter in Marion, Lynn, or Polk counties, you can learn more about Ryan and the team at Johnson & Taylor by visiting the website johnsontaylorlaw.com. You can also call 503-990-6641. Thanks for listening, and be sure to subscribe so you don't miss future episodes covering divorce, custody, and other family law topics in Oregon. We really appreciate it. I'm Sean O'Connor. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.